Welcome to another episode on the Law Rapport. This episode is entitled Episode 53B. In Episode 53, we dealt with how to determine intention in criminal cases. In Episode 53A, we dealt with different categories of intention, negligence, recklessness, etc. Now, today, we are going to deal with two forms of intention in criminal cases: basic intention and specific intention. Before I do, this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Welcome back. Now, specific intent crimes are those offenses where the prosecutor must prove beyond a reasonable doubt that the defendant intended to commit a certain harm. This means a specific intention is a necessary element of the offense itself. For example, in offenses of murder, robbery, and burglary, conspiracy, solicitation, embezzlement, forgery, theft, false pretenses, and attempt offenses, specific intent is a requirement of the offense itself. In contrast, basic intent crimes are offenses where the prosecutor simply has to show that the defendant committed a criminal act. There is no concern as to whether the accused person or the defendant actually intended to produce a specific result of that act. Examples of such offenses are assault, battery, kidnapping, rape, arson, false imprisonment, and driving offenses, driving under the influence of alcohol or drug, etc. These offenses or these types of crimes are associated with what is called the mens rea and the actus reus. And as previously described, the mens rea is the guilty mind and the actus reus is the act itself. Now, in the case of Majewski, Lord Jones, giving judgment in that case, indicated that a crime was one of specific intent if the mens rea went further than the actus reus prohibited. In other words, that the crime was one of ulterior intent. This would make sense in, for say, let's say a case of burglary or criminal damage or a case of damage with intent to endanger life. In the same case, Lord Simon in that judgment advanced a slightly different definition. He indicated that crimes of specific intent required a purposive element. The distinction between crimes of specific and basic intent is demonstrated in the case of Regina and Lippman, a case dealing with intoxication. In this case, a man who had voluntarily taken LSD struck and asphyxiated a woman while hallucinating, believing her to be a snake. The man was found to lack the specific intent required for murder, but his actions satisfy the basic intention of manslaughter, that of recklessness. While it has been argued that there is no consistent principle behind the distinction, there has been some judicial effort to suggest a means of categorization. So, to be clear, the actus reus refers to the physical act of the crime, and the mens rea involves the intent factor of the crime or the mental state of the defendant's mind. For an offense, a specific intention must be an element of the offense itself. And for basic intent, the prosecution does not have to prove that the defendant intended the result of his actions. This has been a very short episode just to round off this era of criminal law. I hope I have been of some assistance to you. If you have any questions, please leave it in the comment section below, and I will see you in another episode. Thank you for watching. Bye for now.